Each side will have 30 minutes for argument. With, if we have any preliminary matters, Mr. Clerk?
No, Your Honor.
Then call the first case.
State of Tennessee versus Torrian, Seantel, Bishop.
Morning, Your Honors. May it please the Court. Jessica Butler with the Appellate Division of the Public Defenders Conference. On behalf of the appellant, Mr. Bishop. If I could, I'd like to reserve 8 minutes for rebuttal.
All right, thank you.
Thank you. We are asking the Court to answer 2 questions today. Number 1, whether the agreed-upon certified question remains dispositive after this Court's decision in State v. Green. And number 2, what changes this Court should make to the current certified question procedure that is outlined in State v. Preston and Tennessee Rule of Criminal Procedure 37. The certified question procedure is designed to facilitate judicial economy, and despite our best efforts, that is certainly not what has happened in this case. This case has a fairly lengthy procedural history, which I'll just briefly recap. This arose out of a suppression issue, as these often do. Mr. Bishop filed a motion to suppress evidence that was obtained during a warrantless search of his vehicle. The trial court initially granted his motion to suppress. The state asked the court to reconsider its decision based on current Court of Criminal Appeals law at the time. The trial court reconsidered its decision, denied Mr. Bishop's motion to suppress. At that point, he entered a best interest plea and reserved the agreed upon certified question of law. That was appealed to the Court of Criminal Appeals, where they found that the question complied with the rule, but based on existing case law at the time, found that the suppression was not warranted. At that point, we appealed to this court. At that point, State v. Green was sort of in the pipeline. Following Green, this court remanded it back to the Court of Criminal Appeals, at which point they found that the question no longer complied with the rule, and they dismissed Mr. Bishop's appeal. Here we are yet again. So as I said, there are 2 questions before the court today. The first one being whether the question remains dispositive. We would assert that whether it's before Green or after, the question remains dispositive. So everyone was in agreement at the trial court level that the sole basis for the warrantless search of Mr. Bishop's vehicle was the purported odor of cannabis. That was—
Ms. Butler, if I could interrupt you for a moment. I'm wondering, so in the initial CCA opinion that kind of dealt with the issue before there was an intervening change in the law, if I'm remembering correctly, the CCA relied on not just the smell of marijuana alone, but also Mr. Bishop's, the way in which Mr. Bishop answered the question about, when he last had marijuana in the vehicle. He said it's been a minute. So it seemed that, at least in that opinion, the CCA did go beyond the mere fact of the smell, the officer smelling marijuana. What do we make of that? I mean, does that change, I guess, the nature of the question that's before the court, or are we still sort of strictly, I guess, bound by the exact wording of the question that was certified?
I don't think that it changes the sort of framing of the question. And as far as that statement is concerned, I think in terms of how the state is arguing it today, it's really sort of a double-edged sword. It seems that the state's argument would be no matter how Mr. Bishop answered that question, it would have been a sufficient basis for probable cause. Either the way that it sort of unfolded is the officer asked him when was the last time he had any marijuana in the vehicle. At that point, he was adamant that he didn't have any in the vehicle. The officer asked him again, no, the question is, when was the last time? At which point he said it had been a minute, which is sort of a nebulous time frame. We don't know if that's—
Well, but the fact that he changed his answer to the question, I mean, it's very well established that in that situation, I mean, you can have a sort of an inference of a guilty conscience or whatever, when the an answer is evasive or when the answer changes in the course of questioning. I mean, that's certainly something that an officer can rely on, right, to establish probable cause.
That's correct. And I think that's actually the point, is that either way he would have answered the question, I think the state would have argued it would have been evasive. Either, as the state points out in its brief, either Mr. Bishop would have remained steadfast in saying, I've never had any marijuana in the vehicle, at which point the state's argument would have been that didn't square with the officer smelling marijuana. That would have been an untruthful answer. That could have been a basis. At the same time, this sort of nebulous answer of it's been a minute, The state's also arguing that that is a sufficient basis, even though there's no determined time frame. We don't know if that was 6 months ago, 6 years ago. And the idea that any time, that Mr. Bishop has had marijuana in the vehicle at any point in the past
So
is valid.
did the officer testify that he relied only on the smell? Am I remembering that correctly?
That is correct. So there were
What
actually
is,
sort of.
what is the import of that? If the officer knows about the statement or anything else, but says, I just relied on the smell?
I think that the court has to consider that as well as part of its analysis of whether probable cause existed. If there were other facts that the state could have relied on and chose not to, especially at this point, because we're sort of stuck with the trial court's factual determination at this point. The trial court's factual determination was that the odor alone was the sole basis. And whether its legal conclusion about the probable cause was correct based on the change in the law, I think that the factual determination remains the same, that the officer relied only on the smell despite sort of all of the other factors that were swirling around.
So
this.
part of what I'm thinking of, and I'd like you to address, is Green emphasized that the test is still totality of the circumstances. But if the totality of the circumstances that was actually considered was just the smell, if there's just the one thing and that's the totality that was actually considered, then does that change at all whether the certified question is dispositive? I'm not sure that it does.
And that would be our argument, Justice Kirby, that it does not. So our argument is that the totality of the relevant circumstances is the smell. And obviously in the state's brief, they point out that the totality standard requires the court to look at all relevant facts and circumstances. Our argument would be that while the state's focusing on the word all, the word relevant is really the sort of linchpin to that, and that there were a number of additional facts and circumstances that took place over the course of this stop, but ultimately the only relevant fact was the odor. And so regardless of whether we're under totality standard, that remains the only relevant fact.
And the trial judge didn't consider any other circumstances, right? Only the odor, only the smell.
Ultimately, no. So there was some discussion towards the end of the first suppression hearing, I believe, about some of the other issues, Mr. Bishop's status as a probationer, the suspended license. But ultimately, the trial court comes back to the basis for this search was the odor and the odor alone, based on the officer's testimony and based on the rest of the proof. So the trial court's understanding was that that was the only relevant factor.
And as I look at, to follow up on what Justice Kirby asked you, as I look at the certified question says, quote, based exclusively on the allegedly plain smell of marijuana, right?
Correct.
So that is the totality of the circumstances.
Correct. That has been our argument the entire portion of the appeal.
Okay, and so why, Ms. Butler, does Green not change the analysis here of whether this question is dispositive?
So my understanding of Green is that Green states that the odor alone cannot give rise to sufficient probable cause. It has to be the odor plus some additional facts or circumstances that are considered. And here, I think our argument has always been that the only fact that was considered by the officers, by the trial court, was the odor. And so that is the totality of the circumstances. And because Green requires something additional, and we don't have that here, the question as written.
So does
Well,
Green actually
Yeah, no, go ahead.
Go ahead.
I think we're going the same direction. I mean, we made clear in Green, we're not creating a new rule, didn't we? We simply said that the totality of the circumstances is what should have been the standard all along.
That's correct.
Yeah.
And there was,
that's correct.
in that case,
Additional.
factually, there was
It's-
one
yeah.
additional thing to consider, but what you're talking about is the negative inference from that. You're saying, well, if there's not the additional circumstances, if there's not at least one additional circumstance in addition to the smell, that's not enough. But I did not read that negative inference into Green.
I think the way that I would answer that is Green requires the odor of cannabis plus additional facts.
Where do you find that in Green? What language in Green would you rely on for that purported holding?
Well, the court's analysis, it discusses the fact that the sort of strong odor by itself would not be sufficient, but there are additional facts over the course of the stop. For instance, the backpack that neither party would take ownership of, some of their body language over the course of the stop. Those are some of the additional facts that the court looked at in Green and said, those facts in conjunction with the odor is sufficient for probable cause. And our argument is that here we don't have those sort of additional facts. There's no body language, and the answer that Mr. Bishop gave is not sufficient under Green.
Well, but the fact is, I mean, even after, the legalization of hemp, I mean, we're always dealing with probabilities, right? I mean, when we're looking at probable cause, as the name suggests, we're dealing in probabilities. And, even post the legalization of hemp, a positive alert from a drug dog, an officer's smelling the odor of marijuana, true, it may not, with 100% certainty be indicative of, the presence of an illegal substance. But that was sort of always the case, right? Because it could be that even if it did detect something, it wasn't there presently, it was there 2 weeks ago. I mean, you're always dealing with probabilities. And so the fact that it could be a lawful substance instead of an illegal substance doesn't necessarily mean that the smell alone or a positive alert from a drug dog, it isn't still establishing probable cause. Not certainty of, but probable cause for the presence of an illegal substance.
Respectfully, I have to disagree, Justice Campbell. And of course, obviously, you all wrote Green, but my understanding of Green is that the discussion of those additional factors indicates that the smell by itself is insufficient, that the officer has to observe something additional in order to establish probable cause. Yes, probable cause is sort of a nebulous standard, and we are dealing with probabilities, but if there is a substance that is both legal and illegal, and an officer is unable to determine its legality or illegality based only on the smell, then the probability can't flip in favor of the officer finding some sort of illegal or evidence of a crime when the substance is entirely legal in some form.
Ms. Butler, I want to make sure that I understand your argument. Are you saying that under the totality of circumstances test that we articulated or reaffirmed in Green, that there has to be more than one circumstance? Or could the totality of the circumstances test be met by only one circumstance?
I would say that if the circumstance is only the odor, then that is insufficient for probable cause.
Well, in this case, what this court needs to do, is it not, is simply to determine whether the question is dispositive.
Correct.
Or not. We're not really getting into the merits. But all we would do is simply then remain, if we were to say it is dispositive, or for whatever reason that it needed to be considered on the merits, we would send it back to the CCA, correct?
That's correct, yes. It would be sent back for reconsideration in the Court of Criminal Appeals. The only, I think, argument is whether the word exclusively sort of makes the question no longer dispositive. Yeah. But our argument is that that singular circumstance.
But in fact, if Green really didn't change the standard, it's a little difficult to say that because of Green, the question all of a sudden became not dispositive, right?
That's correct, and that is our argument as well, that Green did not change the law. Green is sort of a clarification of the law, but not a change in the law, and so the Court of Criminal Appeals initially determining that the question was dispositive and then deciding that in light of Green it no longer is, doesn't square with the fact that the case law itself has not changed.
Ms. Butler, I must ask you this question. I'm not sure it relates to what we are deciding today, but there is a distinction between this case and the Green case. The Green case was a dog sniff case,
Correct.
And Mr. Bishop's case involved a trooper sniff.
Yes.
All right, so does that make a difference who the smeller is in deciding this case?
I don't think so, Justice Tarwater. So there is case law from the Court of Criminal Appeals that says that they are treated the same for purposes of determining probable cause. And I don't think that Green says otherwise. So I think that the analysis should be the same.
Okay, if we may, let's kind of direct your attention to the second question.
Yes.
To the certified question procedure.
Absolutely. So I think that there are a few issues with the current procedure for certified questions. I would say that the biggest one is probably this issue of whether the question is dispositive. Obviously, that's the hang-up in our case, and that seems to be the hang-up in many of these cases. And I don't think that the problem is simply that the criminal bar is misunderstanding what the word dispositive means. But I do think that there is a disconnect occurring between the trial court and the appellate court for a couple of reasons. Number one, I think that we have a situation where the parties at the trial court level are intimately familiar with the facts of the case and make a determination that the issue is dispositive, draft a question, and then there's sort of a switchover, right? The district attorney's office is not handling the appeal. It's someone from the attorney general's office. And then the appellate court is reviewing it, usually from sort of a cold record. We don't usually have much to go on except for the transcript from the suppression hearing and the question itself. And so there seems to be something lost in translation about why the parties below believe that the question is dispositive, and then on appeal, the appellate court and the state are not in accord with that. And so part of that, I think, is just often the record is not sufficient for the appellate court to make a full determination. And a change to that would be simply requiring the parties to put more on the record. This is one of the few scenarios that I can think of where this court or the appellate court is not reviewing a trial court's findings. Trial court is not required to make any findings with regards to whether the question is dispositive. And so this is one of those scenarios where instead of this court reviewing the trial court's careful consideration, they're sort of just looking at the question and trying to backtrack and figure out why the parties believe the question is dispositive, and oftentimes they are not finding that connection. So either requiring the parties to put more on the record or requiring the trial court to make some sort of finding that this court can review, I think would greatly improve the current situation that we have as with regards to the question being dispositive. And the federal rule talks about this somewhat extensively in the comments. They mention on multiple occasions that it is important for the government to be in agreement that the question is dispositive, that in fact the government is in the best position to determine that the question is dispositive. Our own rule requires or states at 3 different points that the defendant has to obtain the consent of the trial court and the state, and yet at the appellate level, that agreement doesn't actually mean much because the appellate court makes the final determination. So more emphasis on the agreement that is carved out between the parties and the trial court's understanding, I think would greatly improve that.
Ms. Butler, what's your understanding of, I guess, the nature of the agreement between the prosecution, the state and the defendant? Is the agreement that the defendant will have the right to appeal or the right to seek an appeal, the right to ask, a court to review the certified question? Because I think that is a pretty significant difference between our rule and the federal rule, and perhaps one of the reasons why, what federal courts do in just vacating the guilty plea and sending it back may not be a feasible solution here. So if you could just give me your understanding of kind of what's happening, what the parties are actually agreeing to.
I think in agreeing that the question is dispositive, the state is agreeing that the case should not just be appealed, but that the case should be heard on the merits because the question resolves the case one way or the other. I don't think it's simply an agreement that you can appeal. I think it's an agreement that the question is dispositive and therefore the question should be heard on the merits. And because of that, the state shouldn't be allowed to sort of do this thing where they often do, where they enter into an agreement with the defendant that the question is dispositive, that the question should be heard on the merits, and that they are giving their endorsement that the question should be heard on the merits, only to then sort of revoke that endorsement, change its position on appeal, and then when the appellate court finds, absent that endorsement, that the question is not dispositive, dismisses the appeal, but the guilty plea remains.
So what does dispositive mean in this context? Does it go more to the type of motion, for example, that's the subject of the certified question, or does it really go to the merits of the substantive issue that has to be decided in the motion?
We would argue that it goes to the substance, because the case law suggests that dispositive means that the court cannot sort of reverse and remand. It has to either side with the defendant or side with the state. There's sort of no middle ground. So that means that the merits of the question are really what need to be reached when the question is found to be dispositive.
Well, isn't part of the issue here, and you talked about how it changes the approach of the state. When it may change from the time it's the trial court level to it gets to the appellate level, but we do have a different dynamic here in our state, because the Attorney General represents that, and we historically have not bound the Attorney General by what's happened at the trial court. So if we did what you're saying there, we would, or considering that as part of the problem, would really be, if we did anything to that, be tying the hands of the Attorney General, would it not?
I'm running short on time, but I'll try.
No, you
to
finished answering the question.
I don't think so. So regardless, I think the Attorney General's office is still bound by waiver principles. So they are not allowed to sort of raise new arguments at the appellate level. And that's essentially what we have here, is that they have raised a particular argument at the trial court level that the question is dispositive. And then they have changed course and decided it is not dispositive. And I do understand that there's some tension there because it's a different entity reviewing the case, but ultimately the state is the state, and the state has to be bound by that initial agreement that was entered into, because it is, in essence, a contract of sorts.
That's not what our appellate court said in Abdul-Rahman, was it?
No, Your Honor, but I do think that this is truly the only sort of context that I can think of where this happens, where the parties, and it's usually a defense attorney, the district attorney, and the trial court enter into this agreement. The defendant is really not part of that process. And then when things sort of go belly up, the person who is sort of left holding the bag is the defendant, and that is usually based on the state rejecting that initial endorsement.
Thank you.
Thank you, Your Honors.
Good morning, Your Honors, and may it please the Court. Matt Cloutier on behalf of the state. Since they were first permitted nearly 50 years ago, Rule 37 certified questions have been an exception to the general rule that there's no right to appeal from a guilty plea. And since the beginning, that rule has always required that the certified question be dispositive of the case. When a question doesn't satisfy that requirement, the appeal is dismissed for lack of jurisdiction, and the guilty plea stands. That result may seem harsh, but it makes sense. For one thing, jurisdictional rules are harsh by nature. And for another, the whole purpose of permitting certified questions like these is to facilitate the efficient and final resolution of cases. So if a particular certified question doesn't lead to a case dispositive outcome, it's not serving that purpose. Turning to the specific certified question here, we think this court should affirm the dismissal of the appeal because the question is not dispositive of the case. First, it's inconsistent with controlling precedent, and second, it fails to account for important material in the record. And this legal and factual mismatch means that no answer to this certified question can ever be dispositive of this case. Now, before getting further into that first point, I do want to take a moment to address the second question that this court added in its grant order, which was whether the parties had input on whether changes should be made to the certified question procedure. And our sort of bottom line answer, I think, is no, but there is still room for this court to add clarity into the way that the rules are actually administered in practice. So I think to the extent that there are problems with the way the rule is working on the ground, and I do think there's some agreement between myself and my friend on the other side on this point, I think it stems largely from the suppression context. And in our view, that's because these suppression decisions are by nature rarely dispositive of the case. I think as this court said in Meeks, a suppression-related decision in recent years, the act of granting suppression usually leaves the state with the option of proceeding on unsuppressed evidence. So I think by definition, the fact that the state can proceed means that the answer to that question is not dispositive of the case.
Let me,
Well, but-
oh, go ahead.
Go ahead.
Go for it.
Let me probe for a moment the AG's role in disagreeing with the trial court prosecutor on whether the question is dispositive. I'm trying to think through how you do that. The trial level prosecutor is the person who has really complete discretion about whether to press forward with the case or not. He or she has a feel for the evidence, for the reliability of the witnesses, all of those kind of nuances that go into a prosecutor's decision about whether to go forward with a case. How then can the AG so routinely, I can envision limited exceptions to this where it's really based on a pure legal question, but for fact-intensive issues like suppression, which is the main topic of certified questions, how can the AG come in as a practical matter and say, no, trial level prosecutor, I say you would go forward with this case, even if the question goes the wrong way? I'm trying to think about how that squares with the role of the trial level prosecutor.
Absolutely, Your Honor. So I think the short answer is that we understand the dispositive requirement to be a jurisdictional threshold for appellate review. So in our view, and I know this came up in the argument earlier today, but I think in our view—
Jurisdictional or not, that's a separate question. I don't view it through that lens. If the prosecutor at the trial level says, if this question goes the wrong way, I'm not going forward with this case. That's what he or she is saying when they agree that the question is positive. They're saying, I'm not going to go forward with this case.
Well, I don't think that's how we see it, Your Honor, and I want to push back on that a little bit. I think we offered a way to get to a similar result, I think, by having the trial court conduct a more elaborate kind of plea colloquy, more akin to what this court faced in Daly.
Then in that situation, then the question becomes, okay, is that sufficient? Is it, are the factual findings enough? Is the explanation on the record sufficient? The AG still is in a position to say, no, that's not good enough. And that's what I want to get at.
Well, 2 points in response to that, Your Honor. The first is that I don't think we agree. I think what this court encountered in Daly was a scenario where the prosecutor said on the record that without this evidence they could not proceed, and that was sufficient to conclude that the question was dispositive. We don't think that enables the state to change position in quite the same way that they are here, and that's because that, unlike I guess what we're faced with in this case, is kind of an express commitment to a particular trial level strategy and of a more factual nature, I think, too, which is also relevant. And that takes me to the second point I wanted to return to, which is I think when we understand, or what we understand about what the state's doing when it agrees that a particular question is dispositive, is that it is necessarily offering its opinion on a legal jurisdictional question. And that is the sort of thing that courts and parties are traditionally able to reach differing conclusions on. And I'd point this court to what it said in several of its certified question cases.
What I'm getting at is whether it's really appropriate for the AG to look at a fact-intensive issue like a suppression issue and say, no, if I were the prosecutor, I would reach a different conclusion. Is that affording appropriate respect to the discretion, sole discretion, that our system gives to the trial level prosecutor?
If that's what were happening, I think it might not, but I don't really understand that to be what the Attorney General is doing. It's not a suggestion or a view, I guess, that the state should proceed at trial, as much as it is that the way that the suppression question is answered doesn't rule out the ability to proceed at trial. Again, for a question to be dispositive, and I think my friend on the other side and I agree about this as well, it has to leave the court with only two options, either affirm the conviction or reverse and dismiss the charges. So we understand that to mean that if there is any ability to proceed at all, the question is per se not dispositive. So all that to say, we don't understand the Attorney General to be taking a position, I suppose, different from the prosecutor about whether they would or should proceed, but only about the fact that they could technically proceed on whatever evidence might be left, even if the suppression question is ruled on.
But you would, oh, sorry, go ahead.
Well, let me talk about public policy for a minute. Obviously, certified questions were set up to make the system more efficient, to allow for quicker review, to allow for the settling of cases. Would you agree with that?
Absolutely, Your Honor.
All right. Well, hasn't our procedure gotten off tracks for that purpose right now as a practical matter? I mean, we see so many of these cases that get dismissed because it's not dispositive, primarily because it's not dispositive. It seems to go against the very function of the rule. So have we gotten too far down that track? I mean, I'll give you a prime example. When I was a trial court judge, I can give you multiple examples of cases I had in which involved very good defense counsel that would come in and say, well, Judge, we talked about a certified question, but I'm not going to certify a question because I'm afraid it'll get dismissed. And so instead, we'll have a bench trial or we'll have a full trial. It seems to just has gotten to a situation where it's not doing what it ought to do. So in that situation, as a court of last resort, should we not look at ways to make it better?
So two responses to that, Your Honor. The first is that, yes, we do agree that I think this is not working out as intended or certainly not in a way that I think is ideal. But as I noted earlier, I think the reason for that stems from the kind of, I suppose, over-invocation of this for non-dispositive suppression questions. So we think the real solution here is not to sort of retire the procedure or revise the procedure as much as it is to clarify the way that it actually applies to truly dispositive issues. Again, we understand this Rule 37 procedure to be kind of a narrow carve-out to the usual trial and appellate process. So I think certain cases, like say a motion to dismiss an indictment for lack of territorial jurisdiction, for instance, it's really easy to see how that's dispositive because obviously if that motion is granted, the case is over. But I think most suppression issues just are categorically different from that. Again, I think as this court said in Meeks, the state usually does have the option to proceed. So what we think is that there's room for this court to clarify, I guess.
Maybe part of the issue is what you just described. In viewing the issue as jurisdictional, I'm not sure I agree with you, I'll just say that. But in viewing it through that lens, the AG's office is looking at certified questions to see if there's a microscopic path for the trial level prosecutor to go forward. The trial prosecutor is looking at it from a pragmatic standpoint and assessment of the evidence. And the AG's office is not respecting that role. They're saying, I can see a very slender path for the trial prosecutor to go forward, so no dispositive question, appeal dismissed.
So, Your Honor, I don't want to resist the idea that I think that is happening in some of these cases, but I do want to stress two things, I guess, in response to your question. Again, I do think we view this as jurisdictional, and I guess that's first because this court said so recently in its decision in Scott. Back in 2021, it referred to the dispositive requirement as jurisdictional, or an issue of jurisdiction, I think, to use the court's phrasing. But we also understand it to be sort of a necessary byproduct of the way that our appellate rules are structured. Again, our baseline kind of rule in this context is that there is no right to appeal from a guilty plea. There is a carve-out in Rule 3B so long as the defendant complies with Rule 37. But then we understand Rule 37's carve-outs to be, Rule 37's parameters to be kind of what sets the bounds on appellate jurisdiction. If a defendant stays within them, the appellate court has jurisdiction. If he doesn't, then the appellate court has to dismiss. I think that's akin to how this court views other issues of appellate jurisdiction, and we don't see why it should be different here.
But let me ask you about that, counsel, and about the Scott case. The language that you rely on was actually in a footnote in Scott, right?
It was, Your Honor.
All right, and as I understand it, the footnote was based on our precedent that appellate courts cannot consider questions or issues outside of the certified question in this context. Isn't that? How is that remotely similar to what we have?
So we understand, I suppose, to those prior cases, we understand those to be saying that anything outside the scope of the certified question necessarily kind of is outside the bounds of the court's appellate jurisdiction.
Right.
So what I understood the court in Scott to be saying is that these parameters set by Rule 37, in that case, right, those older cases, kind of about the bounds of the question, are necessarily jurisdictional, and I think that extends to the other parameters of Rule 37 as well. Because again, I think if
So you viewed that comment in the footnote in Scott as really taking the jurisdictional issue to a whole different level than the prior case law?
No, Your Honor. We understand it to be, I guess, expressing the broader proposition that those earlier cases do stand for, which is that, appellate courts are confined to reviewing the question as properly certified under Rule 37. So if it fails to comply with some aspect of Rule 37, the appellate court lacks jurisdiction. I think that's the natural reading of all of this court's cases since Preston, where I think it's been, demanded rigid adherence. It's demanded strict compliance in Armstrong. And I think the implication when a defendant fails to do that has always been to dismiss for lack of jurisdiction. So I think that's, again, sort of a necessary reading both of this court's precedent and of the text of the rules themselves. But I think if I can just take a broader step back and say, I think, again, this makes sense when you return to what this rule is supposed to be doing. If indeed the goal, I think, as I was just conversing with Justice Bivens about, is whether or not these questions can facilitate effective final resolution of a case, I think it necessarily has to be a dispositive issue. And I think I'd also point this court back to, we cited in our brief in this case, but it's United States versus Bundy. It's a case out of the Fourth Circuit. And it's notable because the federal rule that my friend on the other side points to does not contain a textual dispositive requirement. But despite that absence, 6 federal circuits have read one into the rule because I think they recognize that a rule that enables courts to address non-dispositive issues doesn't really serve this kind of broader goal of facilitating efficient and final resolution of cases. It instead results in a regime where a question can go up, a court can opine on kind of a narrow, non-dispositive aspect of the case, and then it has to go back down, which sounds a lot more like a traditional interlocutory appeal than I think what this rule is intended to be.
So let's imagine that instead of dismissing the appeal, we remand the case back down for renegotiation. This question was not dispositive, renegotiation. At that level, it goes back to the same prosecutor and said, I told you I can't go forward unless this question is answered this way. So it gets dismissed anyway. So I'm just having trouble with for the policy reasons that Chief Justice Bivens was talking about. It seems to be counterproductive to the actual goal.
I do think it's been counterproductive or been challenging to implement, I think, in a lot of these suppression cases. We're not resisting that idea, but again, we understand that to be a consequence of over-invocation of the rule in the suppression context rather than a flaw with the rule itself. And again, I think if you look at a motion to dismiss a prosecution, the rule works fine. It's straightforward, easy to apply, and it results in a case dispositive issue getting heard by the Court of Appeals. I think where it gets hard is when you have questions that are not clearly dispositive, I think on, often insufficient records, as my friend on the other side alluded to. And I think that is more unique to the suppression context, and that's where I think this court has room to really clarify how this rule is.
But doesn't that again go to the discretion of the prosecutor? At the point that a guilty plea is agreed upon, the prosecutor may know about things that the other side doesn't know about. They're not going to be in the record. They're never going to be in the record because the case has not gone forward. It might be a witness who the prosecutor knows is probably going to fade on them or something like that that's never going to get in the record. So just amping up the requirement, well, we need more findings. We need a bigger record. Does that really serve the overall purpose that we have for this?
Well, to be clear, Your Honor, we're not proposing an approach which would require building out like a more elaborate record. I think all we're asking for is something akin to what this court confronted in Daly, which is, again, in the course of this plea hearing, getting the prosecutor on the record as expressly saying that without this particular piece of evidence, imagine it's their most significant.
How does that help? The prosecutor, the state has agreed this question is dispositive. What does that mean? That means that the case that this prosecutor is not going to go forward depending on the answer to the question. you're just making explicit what is absolutely implicit in an agreement that it's a dispositive question.
Well, the problem, Your Honor, is I'm not sure it is implicit. I think maybe if we were approaching this rule on a clean slate, there's a way to read Rule 37 in which that's the effect it would be having. But the problem is we're not. I mean, this court has been very clear that each court has an independent duty to assess whether or not this is dispositive, and it has treated it like a jurisdictional issue. So I think so long as that precedent remains in place, it doesn't look like that is what the state's agreeing to when it says a question is dispositive.
Well, maybe that's why we added that question to the grant list.
And it may well be, Your Honor, and that is helpful because I would like to return to your broader public policy concerns. And I think our position there is there may well be good public policy reasons to change the way this rule works on the ground. But, we understand, at least for purposes of this case, this court to be cabined by both its existing precedent and by the text of the rule. So those public policy...
Text of the rule is almost verbatim what we held in Preston, is it not?
It is, Your Honor, but I think now it is in the rule, which means to change it, you'd have to institute rulemaking rather than changing the text of the rule through a judicial decision. Now, that's not to say that the court can't sort of expand or interpret or elaborate on what the rule requires, but we don't think there's any way that the court could, for instance, omit the dispositive requirement from the rule through a judicial decision. I think those sort of more drastic changes would require rulemaking, and I direct this court to what it said in Webb, which was that broad sort of changes to procedural rules should come by operation of the normal rulemaking process, not by judicial fiat in the context of a single case. And there, this court was faced with amending the rules of civil procedure, I believe, to incorporate the Twombly-Iqbal standard rather than the notice pleading standard. And its justification for proceeding through rulemaking rather than trying to do it through a judicial decision is that rulemaking permits input from a wider array of interested parties, including members of the bench and bar and general public, and of course the advisory commission. So we think that to the extent these more sweeping revisions to this procedure are needed, those are necessarily the type that are better implemented through a rulemaking process that can account for these policy considerations that are, traditionally not part of the judicial decision-making process.
Mr. Cloutier, if I could take you to the certified question itself in this case, I want to go back, I guess, to my earlier conversation with Ms. Butler and get your position on this as well. I mean, the state sort of agreed to this based exclusively on language in the certified question, and I take Ms. Butler's position to be that because of that language, this question is dispositive because Green said that the smell alone can't establish probable cause. You've got to look at the totality of the circumstances, and this question sort of limits us from looking at the totality of the circumstances. So the answer to this question is necessarily no, it cannot establish probable cause. So probable cause didn't exist in this case, and the item must be, and the marijuana must be suppressed. I mean, why is that not the right answer here in light of the language that the state agreed to in the certified question?
So two responses to that, Your Honor. I think the first reason is that this court has stressed in several of its certified question opinions, but I think most recently in Day, that the court is limited to answering the question as certified. So I think if that's how this court views this question and does answer solely the text of the question, which is whether or not the smell alone supported the existence of probable cause, I think this court runs into a bit of trouble because, again, it has also said that it has to apply a totality of the circumstances analysis in the probable cause context. So I think either the court is, adhering to its decision in Day and considering only the narrow scope of the question and thus foregoing kind of the proper legal analysis, which I understand to be a bit of a problem. And then I think the second point I want to emphasize is that this court stressed in its decision in Daly that the inquiry into whether or not a question is dispositive is record dependent. So we don't understand there to be an approach where the court can solely cabin its inquiry to the text of the question. We think the court necessarily has to look at the record to determine how the question is dispositive, which is how this court articulated the rule in Day. So we think that necessarily entails consideration of the broader totality, both because that's the traditional probable cause analysis and because it's in the record in this case.
But isn't the parties' agreement to a particular wording of the question? I mean, don't they, I guess, by agreeing that this is the question that the court must answer, essentially kind of waive or concede certain, arguments that would rely on other parts of the record?
So we don't think so, and this takes me back to my conversation with Justice Kirby, which is that I think because this rule has been treated as jurisdictional, the various aspects of it that could be construed in kind of a waiver sense don't really work out that way in the Rule 37 context. So I think, I take the point that the state agreed to the text of the question, but, and this comes into play more in the second case that this court will hear this morning, but if the text of the question contains facts that expressly conflict with the record, we don't understand how there could be an approach where the court can permissibly rely on, missing, or facts that are isolated from the broader context in which they appear, or facts that actually contradict the record just because they're in the text of the question. I think a rule that permits that.
Do you agree that the question or the ruling of the trial court was limited to the smell of the marijuana?
I agree that the trial court framed its ruling in those terms, but again, I think we understand that to be not necessarily the way that this court's inquiry should be limited. And again, I'd return to the fact that this court's probable cause precedent demands consideration of the totality of the circumstances. And obviously, I think it's an objective standard, so the officer's states of mind, I think, don't matter under this court's precedent. But I also think in the Rule 37 context, even the trial court's limited consideration of the smell doesn't demand or doesn't dictate the scope of this court's analysis either.
So tell me how our decision in, the CCA clearly relied on our decision in Green to essentially say, okay, it's not dispositive. How did Green change anything with regard to whether a question is dispositive or not?
We don't think it did, Your Honor. We think that Green was a very narrow opinion that stated only what has, I think, long been the law, which is that probable cause demands consideration of the totality of the circumstances, which necessarily forecloses any sort of per se rule about one individual circumstance always sufficing for probable cause purposes.
So in your view, the DA's office was just wrong when it gave the opinion by agreeing to this certified question that this question was dispositive?
I think it's
Pre-Green.
I think that's right, Your Honor. I think our view is that Green did not change the way that the probable cause inquiry functions, and that it has always required consideration of the totality of the circumstances. So this question was flawed from its inception.
Why should you be allowed to change your position on that?
I think, again, because we viewed this as a jurisdictional issue. And I do want to be clear, it's not, we're not taking the position that the state's change in position is what dictates kind of the dismissal of these cases. Again, this court has been very clear that courts have an independent obligation to assess whether or not a particular question complies with Rule 37's requirements. So to be clear, yes, the state is changing its position, but if courts have an independent duty to assess this, we think the interests actually favor the state being able to change position when appropriate to ensure that the court is actually reaching the correct answer. So again, here, we don't understand there to be some change that...
Well, part of the dysfunction in the system, and it is dysfunctional now, I mean, I think everybody agrees on that. Part of the dysfunction may be that the appellate courts have adopted the same MO of looking at, is there another little tiny path that the prosecutor could have taken to press the case forward regardless of the answer to this certified question? Maybe the dysfunction is at using that lens at the appellate level as well.
Two responses to that, Your Honor. The first is that we understand that approach to be dictated by this court's decision in Armstrong. This court expressly rejected a substantial compliance approach to these questions, which I think the Attorney General's office and certainly the courts have taken to mean that a defendant does have to comply with every aspect of Rule 37 to receive appellate review on the merits. The second thing I want to note, though, is that we do agree that I think there are cases in which the Court of Criminal Appeals has taken too harsh an approach to these questions. And one strain of cases I'd like to emphasize, and I think this will come up a bit more in the second case this morning, but Rule 37 contains a scope and limits requirement, and that requirement, unlike the dispositive one, has yet to be sort of fully interpreted by this court. And we think that's one where the Court of Criminal Appeals opinions have perhaps taken on too harsh an approach or too demanding an approach in the certified question context. There's a strain of cases that have adopted what I think I'll call a four corners approach, where they've said that each certified question has to include everything the court needs to determine whether or not it complies with Rule 37. They've gone so far as to say that the court shouldn't have to look at the record, at the briefing, at the trial court's decision, or at anything else. And I think that's really hard to square with the text of Rule 37. It certainly doesn't flow directly from it. And I think that is an area that makes this rule really ripe for confusion and for difficult application, and certainly difficult compliance for defendants. So I think if there's an aspect of Court of Criminal Appeals precedent that really warrants, I think, clarification and correction, it would be that. I think the dispositive requirement, though, I take the point that some of these kind of critiques can appear nitpicky, but that is technically, easily applied in a way that I think the ill-defined scope and limits requirement is not. So I think under Armstrong, we understand strict compliance to be necessary with the dispositive requirement. This court is, of course, free to revise that, perhaps through rulemaking. But I think right now that is the law, and I think those are meaningfully different in kind from the scope and limits cases where I think we understand there to be a real implementation problem.
Going back to policy for a moment, of course, you have a situation here where if a defendant enters the plea in this situation, subject to a certified question, it comes up, CCA says, or any appellate court, CCA or us, says, nope, not dispositive, dismissed, then the conviction stays in place. Isn't that really harsh? What would be wrong with a procedure that says, okay, that may be what results, but then it goes back and the defendant has the right to consider whether he wants to withdraw that guilty plea or not?
So in our view, there is nothing wrong with that as a matter of policy. We think that's certainly the sort of thing that the court could and perhaps should consider in the rulemaking context. I think where it becomes a bit more challenging, though, is, at least as far as I've been able to discern, there isn't any mechanism to facilitate that under current Tennessee precedent or under the current Tennessee rules. So all that to say, a process in which the defendant has the option after dismissal of one of these for lack of jurisdiction to withdraw the plea probably does have some benefits. I think we see that in the federal system. But I do think it's hard to square with kind of Tennessee law as it exists right now. And the one thing I will say, just as a sort of kind of response to that suggestion on the merits, I do think that's a little bit harder to square with the efficiency-related goals of this rule. Again, the purpose of this rule is to facilitate the final resolution of cases. So I do think it would certainly be more fair to provide an option to withdraw the plea after a dismissal for lack of jurisdiction, but it definitely wouldn't be more final. So we really think that the better solution here, perhaps, is to ensure that this rule is limited to truly dispositive issues. And that may require elaboration through precedent, it may require elaboration through rulemaking. But I think to the extent we're kind of having a discussion about kind of whether this should be a broad rule that permits more of these appeals or a narrow rule that permits fewer, I think that's necessarily the sort of policy discussion that belongs in the rulemaking context.
But aren't we basically where you're talking about right now? Hasn't it become so narrow that it looked at only for dispositive questions, and by the interpretation of that, we're exactly to where we've narrowed it down to almost nothing now?
Well, to be clear, Your Honor, we don't understand there to be sort of an inherent problem with this being a narrow carve-out. I think to the extent there's problems here, it's that narrow carve-out has been used in contexts where it doesn't naturally fit. So, I take the point that people are concerned, I think very understandably, about the dismissals of these appeals when they wanted to have their question heard on the merits. But again, I think that stems from differing visions of what this rule is for. So I think in our view, it should be a narrow rule that shouldn't lead to a lot of dismissals of these appeals. I think to the extent we want a broader rule that permits more suppression-related appeals, for instance, I do think that's the kind of thing that would require either abandoning a lot of this court's past decisions or revising the text of the rule itself.
Mr. Cloutier, what, in your view, forecloses us from adopting, a policy whereby rather than dismissing the appeal and leaving the conviction in place, we kind of vacate the guilty plea and allow the parties to begin negotiations? And you said that you think that would have to be done via rulemaking, but is there a particular, rule or precedent or statute that actually forecloses that option?
Not that I'm aware of, Your Honor. I think the court's precedent has, referred to dismissal of these appeals, and I think has treated that as sort of a case-ending decision. So I think it's perhaps in tension with this court's precedent, but it's certainly not directly foreclosed by it, and certainly not if this court were to go through the rulemaking route, where I think, traditional stare decisis considerations don't perhaps apply in quite the same way.
Would there be any problem with relying on the kind of quasi-contract conception of the plea deal that, that Mr. Bishop's attorneys advocate for?
Not exactly, Your Honor. I think so long as, for instance, if the court were to embrace this kind of daily style plea colloquy approach that we've advanced in our brief, I think there certainly wouldn't be any problem with taking a quasi-contract approach. I think
Is there a problem with that here, in this case?
If I may.
Certainly.
I think there might be, because again, we understand the dispositive requirement to be a jurisdictional threshold requirement, and I think that's the kind of thing that courts are traditionally very reluctant to apply waiver or estoppel style principles to, and we think that would also hold in kind of the guilty plea contracting sense as well. I think the whole idea of jurisdictional rules is that parties are able to change positions with the goal of assisting the court in reaching the correct result. So we don't think that's a natural fit under current precedent. So We would ask this court to affirm.
Thank you, Mr. Cloutier. Ms. Butler?
I'd like to begin by discussing this jurisdictional issue that came up during opposing counsel's argument. And to Justice Kirby and Justice Tarwater's questions, as I was preparing, I sort of started looking at this jurisdictional issue to sort of see if I could trace where that comes from. Obviously, I started with Scott. It does appear in a footnote in Scott. And that's the first time that I can find that this court has explicitly stated that this is a jurisdictional issue. The footnote cites to State versus Springer, and the text in State versus Springer states that appellate courts lack jurisdiction to hear any issue beyond the scope of the question, which, to Justice Tarwater's point, I don't think is the exact same thing as saying this is a matter of jurisdiction, and certainly not to be read in the way that the state has read it to mean that they can, one, change their position on appeal because it is a jurisdictional issue and therefore waiver and estoppel arguments don't apply. But also the idea that this is sort of coming up in a bit of an atextual sense. Obviously, the rule itself has this sort of scope and limits requirement, but also a dispositive requirement. So we understand those to be two separate things. And so to the extent that the case law that states that appellate courts lack jurisdiction to hear anything beyond the scope of the question is also being read to mean that the matter of whether the question is dispositive is a matter of jurisdiction. I don't necessarily think that that's exactly what the case law says. And I do think that this jurisdictional issue that we are discussing, if the court were to find that this is not a jurisdictional issue in the way that the state has argued, certainly would clear up a lot of what we're dealing with today in terms of the state changing its position and not necessarily suffering a consequence for doing so. But also that the appeal would be outright dismissed because it's a matter of jurisdiction, rather than simply allowing the parties to return back to the trial court and have the plea withdrawn and sort of go back to their original position. I do want to also point out that this current situation that we have, the state, their proposal is essentially to adopt a sort of daily-like procedure where the state will simply state on the record at the plea colloquy that they can't move forward without the evidence. And to Justice Kirby's point, I think that by agreeing that the question is dispositive in the trial court, that is essentially what they are saying. It's an inference for sure, but by stating that the question is dispositive, they are essentially arguing that they cannot proceed should this case be found, should the case go up and found in the defendant's favor. So ultimately, I think that the state's proposal here is really a distinction without a difference in terms of what we currently have. They are not proposing anything outside of what is currently happening with the trial court and the state sort of agreeing that the question is dispositive at the trial court level and then on appeal deciding otherwise. And they are, of course, incentivized by sort of keeping the status quo because from a contractual standpoint, what's happening is that they are entering into an agreement. They are agreeing to, as I said earlier, give their endorsement that the question is dispositive, that the issue should be heard on the merits. And then at the appellate level, they are revoking that endorsement. And because in the federal rule, and also I think it's in terms of our text in our Tennessee rule, it's so important that the defendant obtain the consent of the state and the trial court. The federal rule talks about the fact that the government is in the best position to determine that the issue is dispositive. Even in the state's brief, they at one point mentioned that the parties are in the best position to make this determination for themselves. So the idea that they can make a determination at the trial court level and then revoke their endorsement, and then the appellate court is sort of left with the state's understanding that the question is no longer dispositive. And I was very hard-pressed to find cases where the state argued that the question wasn't dispositive and the appellate court disagreed. So more often than not, because the defendant does not have that endorsement from the state, the appellate court is sort of defaulting to the question is not dispositive. And so for that sort of issue alone, I think that the court should look at a system where if nothing else, the defendant should be allowed to withdraw their guilty plea just from a contractual standpoint, because what's occurring now is that they are giving up their right to proceed to a jury trial. They're giving up their right to sort of continue plea negotiations. And in essence, the state is not giving up anything because they are allowed to change their position, and then ultimately the guilty plea stands.
Ms. Butler, what you just said about the court's finding that in certain cases that the issue was not dispositive, regardless of what if I understood you correctly, regardless of the position that the state took, that the courts would find that the question was somehow deficient, and then find that the appeal should be dismissed regardless of the position that the AG took. Did I understand you correctly?
No, my point was that most often what happens is that the state will assert on appeal that the question is not dispositive, and the appellate court will simply agree with that position. There are very few cases where the state has argued that the question is not dispositive and the appellate court has found otherwise. So it's sort of the default in practice that when the state argues that the question is not dispositive, again, sort of going back to that, we require the state's endorsement to bring this forward at the appellate process anyway, and when the state sort of revokes that endorsement, the appellate court is finding most often that the question is not dispositive.
Okay, in this case, you had 2 trips to the Court of Appeals.
Yes.
The Court of Criminal Appeals. And what was the state's position the first time?
The state's position the first time was that the question was dispositive. So to the extent that I understand my friend on the other side to say that the DA's office was incorrect in asserting that the question was dispositive, the Attorney General's office was also, I assume, incorrect in stating that the question was dispositive, because that was their position at the original appeal. It was only once this court remanded it back for reconsideration in light of Green that they changed their position and stated it was not dispositive. I'll try to wrap it up. So if the court has no other questions on that, I would just wrap it up by saying that we would ask the court to find that the question is dispositive. It has always been dispositive based on the agreement by the parties at the trial court, based on the trial court's understanding of the facts and its factual determination, and based on this court's decisions in Green. I don't think that Green has changed the outcome of this case at all. The question remains dispositive, and we'd ask the court to remand it back for reconsideration in the Court of Criminal Appeals. Alternatively, if the court does adopt some changes to the procedure, we'd ask that the court find those to be in favor of Mr. Bishop, and if the court adopts a procedure that allows him to withdraw his guilty plea, we'd ask for that as well. Thank you, Your Honor.
Thank you very much, Ms. Butler. Counsel, we appreciate it very much. Excellent job of arguments. We're going to need to take a brief recess. We'll be back shortly.
All rise.